Welcome to week 4, and this video is to recap our discussions on property interests covered in week 3. During week 3, we spent time looking at state law concepts. We learned that federal transfer tax laws are imposed on the transfer of property and that property interests are determined and defined under state law. Before we can understand anything under federal law, we need to understand those property rights which are defined by state law. Once we know what the rights are under state law, then we use the federal law to determine the property rights to reach. So we're going to focus on property rights or forms of ownership under state laws. And most forms of property ownership are a form of common law, and some of those basic principles are still with us today. Property interests can be divided in a number of ways. One way is a freehold interest, and that's where the terminal date of the interest is indeterminable since it terminates at death. Another way to hold an interest is a non-freehold interest, and that's where the interest is determinable, such as a leasehold interest. So there are 3 forms of freehold interest. They are referred to as fee simple absolute, which is the highest form of ownership, and the title can not be defeated. Basically, it's all on you. You pay the taxes, and all the responsibility lies with you. The next form is fee simple defeasible, which is property you own, but something can defeat the property's title. And finally, the third form of freehold interest is a life estate. Other forms of property interest are single ownership or ownership in severalty, which is, for example, property owned by a single person or a corporation. And finally, you can own property jointly, so it would be joint ownership. So if we divide property, say, between someone who has a life interest and someone who has a remainder interest, we basically are saying that ownership can be broken up based on time, which is referred to as temporal interest. So you can take one single property, this is one property, and create ownership among different people at the same time. So there are 2 or more people who own the whole thing together on some sort of proportional basis, which means they have an undivided interest. And that's also known as concurrent ownership. So temporal ownership is based on time. And that's where it's first owned by the person, for instance, with the life interest, and then next by the person with the remainder interest, which is the interest that's received at the death of the person who has the life interest. So about successive interest in trust. If you have a legal life estate, the interest basically that's held for life is referred to as a freehold interest. And that's, again, remember, because that interest is not determinable because it's going to end at death, and we don't know when death is going to occur. Or that initial interest can be for a number of years as opposed to this life interest. And if it's a number of years versus a life interest, then it's referred to as a non-freehold interest. So the person with the life interest is responsible for prudently maintaining this whole property during the life to protect the asset for the remainder man, who's going to get this remainder interest. A taxable event occurs when a third party, the grantor over here, transfers this entire asset to the life estate tenant and the remainder man. So thus the grantor, outside the box of the trust, is responsible for the gift taxes applicable to that transfer. The remainder interest that's down here can be to someone other than the person who created the life interest, or the remainder interest can revert back to the grantor. If it reverts back to the grantor does not remove that property out of his gross estate. So you have to be careful with that if the goal is to remove the property out of the grantor's estate. So in our discussion forum, we talked about concurrent ownership, which occurs in 3 basic ways. And those ways are, and we talked about this quite extensively, through joint tenancy, tenancy in common, and community property. So these 3 types of concurrent ownership have a number of things in common. Each has an equal right to income and an obligation to pay expenses related to the property. After that, there are a number of differences, and you all did a really good job, excellent job actually, of bringing out those differences in the discussion forum. So I'm not going to spend a lot of time repeating those discussions. However, I will reemphasize a few points. So regarding tenancy in common, tenants in common may have different ownership interests. For instance, if you have tenant A and tenant B who own 25% of this entire interest each, then they would end up owning 50% of the interest. But if you find that if C owns the other 50%, then what occurs here is they each have a tenancy in common, and they could be obtained all at different times. And so an individual may obtain an interest in a property in different years and many years after one or more other individuals have entered into that tenancy in common ownership. So the way this basically works is each person has their separate interest that they own. You can go to that percentage that they own of that property. And so in this example, we're just imagining or assuming that tenant A owns 25% of this entire property, tenant B owns 25%, and C owns 50%. Or it could be A owns 1/3, B owns 1/3, and C owns 1/3. With respect to joint tenancy, there is one deed with equal shares of ownership held by more than one tenant at the same time. So the terms of a joint tenancy, or even with a tenancy in common, are spelled out in the deed or the title or other legally binding property ownership document. So this type of holding title is most common between husband and wife, and I'm referring again to the joint tenancy type of holding title. And it's also held among family members in general, since it allows the property to pass to the survivors without going through probate. So that's really important. And a lot of times this particular form of ownership is held this way because they want to make sure that it does not go into the gross estate of the grantor, or they want to make sure that if one of the tenants die, that the remainder interest is going to go to the survivors who own the same property as a joint tenancy. So with respect to how the right of survivorship work, as opposed to with, say, the tenancy in common, one of the major differences between the two types of the shared ownership is, again, what happens when the property, when the owner dies. So when a property is owned by joint tenants, the interest of a deceased owner automatically gets transferred to the remaining surviving owners. So, for example, if you have joint tenants A, B, and C who own a house, and this tenant A dies, what happens after tenant A dies, B and C end up being each 50% owners in that particular home, if this property that's held is a home. So that's called the right of survivorship. Again, tenants in common have no right of survivorship. So thus, testamentary control exists with tenants in common, which means the interest owned at death goes again into the gross estate. So property held as joint tenants and community property, basically, and here CP stands for community property, they basically cannot coexist. The property must either be held as joint tenants or the property must be held as community property. If the decedent dies with a valid will, the form of the title prevails. If the decedent dies intestate, the property is viewed as community property. So what is community property? Community property relates to property that are in designated community property states. And we covered that again quite extensively in our discussion forum. So I'm not going to go into it with a lot of detail. I'm just going to again emphasize some key points. In a community property state, all property acquired or accumulated by the husband and wife during the marriage becomes joint or community property. Laws vary among various community property states. However, the basic idea is that a husband and wife each acquire a half interest in the property acquired during the community. Thus, community property is ordinarily defined as everything the couple acquired during the marriage with the exception of separate property owned by either of them individually. Separate property is property that each spouse brings into the marriage, in addition to anything that either spouse acquires by inheritance during the marriage. So, for example, if you're in a community property state, in particular California, earnings is considered property acquired after marriage, and it's considered community property. If you take community property funds and use it to pay on separate property, you risk or will transfer that portion of the property that was separate property into community property. And so the tracing rules are used to convert the portion of that separate property paid with the community earnings to community property. So you have to be careful about that if the intent is to keep the property separate. With that said, I'll wrap up this video, and in concluding, know that state law defines property rights and the federal law taxes those rights and interests. Look forward to this week with you in week 4.